Have you ever lay in bed at night and thought, I wonder how much of my personal information is currently being stored by the government or big businesses? What type of information would they even have? And I wonder whether I could get a copy of it. Well, the good news is that in 2014, the Commonwealth Government introduced significant changes to the Privacy Act, including the introduction of the Australian Privacy Principles. In particular, Principle 12 sets out how you can access personal information that's being held. However, the principles only apply to agencies and organisations that are subject to the Privacy Act. These agencies and organisations are defined in Section 6. Agencies include Commonwealth Government agencies and departments. Organisations are corporations, sole traders, partnerships, unincorporated associations or trusts with an annual turnover of more than $3 million. This means that the Act doesn't apply to state government agencies, small businesses, or registered political parties. Under Section 5B(1)(a), the principles will also apply to organisations outside Australia, where those organisations have an Australian link. Foreign organisations will have an Australian link where they carry on business in Australia and collected or held personal information in Australia either before or at the time of the Act. The phrase "carry on business in Australia" is not defined in the Privacy Act. However, the phrase arises in other areas of law which do provide some guidance. For example, in the case of Bray and F. Hoffman, the Federal Court noted that having a physical place of business was not a requirement to carry on business in Australia for the purposes of the Trade Practices Act. The explanatory memorandum for the 2012 Privacy Amendment Bill specifically states that an online presence collecting personal information from people in Australia is sufficient to meet the requirements of carrying on a business in Australia. However, in the 2005 case of Gebo Investments, the New South Wales Supreme Court commented that where an entity merely had a website that could be accessed from Australia, this wouldn't be sufficient to establish that the website operator was carrying on a business in Australia. So now you've picked an organisation or agency that's applicable, but how do you go about applying? Well, one of the best things about Privacy Principle 12 is that there are no formal requirements for making your request, and it doesn't need to be in writing. Imagine all the annoying ways you could request information from a company by email, letter, telephone, or even carrier pigeon. The agency you've applied to then has 30 days to respond to your request.